All righty. Well, we're going to get started so we can respect everybody's time. And Mark, we appreciate you being back with us again for the second half of the wills and estates. A lot of good information last week. I know this week we're going to continue some of that conversation, or you are going to continue the training and talk also about, as agents, how we might want to have conversations with our clients. And just to reintroduce Mark, for those of you that weren't here last week. So Mark is an attorney out of Nashville. He is, he does all things real estate. He's got a thriving, really business. He co-owns Bell and Alexander, and I've used him for years for all my closings. He's done Steve and I's personal estate. He's done that for many years. They have a litigation team that still litigates in the real estate world. So they do all things real estate. But, several years ago when he did our estate, there was just so many things I learned through that I was uneducated about. And I thought I can't be the only one. So I thought it would be a good training for us. And, we as agents, we're dealing with people's largest assets. And it's important that they protect not only their home, right, upon something happening to them, but, all their other assets. And, that's obviously where estate planning and wills come into play. And again, go back and listen to last week. Mark kind of talks about, some of the pros and cons of one versus the other. And I'll just say, Mark does the Tennessee, does things in Tennessee, but Mark, I don't know if you've got some referrals other places, but we'd love to, if you've got any clients that you want to refer over to him, if he can't help them, maybe he's got some connections that can. So Mark, I'm going to let you take it away and pick up part 2 today. Thanks again for being here and sharing all your wisdom.
Well, thank you, Kathy, and thank you everybody for being here and those brave enough to come back. Last week, we were just talking about the personal plan and the reason for that and some of the advantages. And this week, Kathy had asked me to focus, to build on that and to focus on how you as an agent walk your client through those situations, because there's certain key phrases that you want to look for when you're talking with someone on a listing. The number one is, this property has been in my family for generations. That almost guarantees there's a title problem, because usually it hasn't been probated between the generations, or you have gaps. That doesn't mean it can't be fixed. It just means there's probably an issue we have to work through. And the reason that's important to you is because if you sign a contract with someone and they don't own it, they can be sued by the buyer because they have offered something for sale that they do not own. And so one of the warranties they make is, I own this title, I own this property free and clear, and I have full right to sell this property.
I just had it a minute.
And so you want to make sure that you're not harming anyone. And so that's one of those questions. And so how do you recognize these things? So it's always good to start with a tax record. Tax records are wrong every day. Okay. So tax records are not great places to start. I had a case yesterday. The tax record is wrong by 14 acres. Okay, so we're having to file a lawsuit over 14 acres because somebody says, nope, the county says that's mine. The county's just wrong. They do a great job. They work really hard, but they just take the data that's delivered to them. They don't investigate a lot of that data themselves. And so we want to make sure that we know who our seller is. And so the first thing to do is just look in the tax card and see who they think the seller is, because that's at least some place to start. And if that agrees with the person that you're talking to, and that's a good place. And that's a quick fix, because that takes, probably 30 seconds to determine that through most of the jurisdictions. So that's a really easy start. So if it is an estate, what do we do? The question is to ask, is this estate in probate? Has it been resolved through probate? Was the property held in a trust, which is what we hope it is, because in a trust, we don't care about probate. And so that's the big advantage of the trust over the estate. Is in Tennessee, the restriction that we have is you can't convey property. People say 30 days because there's a statute that says that, but there's another statute that's overlooked that says 60 days. Because a deed can be recorded, if a person passes, a deed that they sign can be recorded for up to 60 days after the date of their death. And so we say that prior to 60 days, we don't need to have a closing, but after day 60, day 61, we can have one. And depending on the nature of it, if it's a trust, we just hold the proceeds and we sell. If we do it through an estate, we have to have everybody appointed, because in Tennessee, once again, and this is different for the jurisdiction. So once again, I'm not trying to speak to anyone else's state, but in Tennessee, a will has no authority until it has gone through the probate court. And so it's just a writing purporting to be a will until the court says this is a will. And so no one has authority at that point to sign contracts, dispose of assets, anything like that. And so if it hasn't gone through court, you want to take them or help them find someone in your jurisdiction that does estate work, because the very first thing is to figure out who owns this property. Because probably within my practice, I would say about 25% of the time, 1 out of every 4 times, the person does not own the property who thinks they owns the property when you're dealing with an estate. Because even in Tennessee, for example, if you die without a will and you're married and you have 2 or more children, and the property was only in the deceased spouse name, that does not go to the spouse. That goes 1/3 to the spouse and 2/3 to the children. And if they're minors, you have to have court-appointed guardians put in, because in Tennessee, you can't just have a parent sign on behalf of their child for estates with a value over $10,000. And so those are just things that we want to make sure of, that we have the authority to sign. And a minor, that problem is fixed by a trust. That's why you want to catch things on the front end. You know, when somebody asks you a question, you want to have them do a trust on the front end, because it saves us from having guardians appointed for the minors. Because the interesting part is, this is why that's such a big problem. I'm taking a little bit of a rabbit hole, Kathy, but I'll get back on track here. Is when a minor owns property and it's court monitored and there's a surviving biological parent, the money cannot be used for the necessities of life for that child. You can use it for extra stuff like camps and sports and trips, but because there's a surviving biological parent, the court says that parent is responsible for all the costs of raising that child. And so that money just goes into account and is invested, and it's court monitored every year. You have to file an accounting every year for every penny. Okay, so once again, one of the values of the trust, I'm not trying to sell it, I'm just saying that it's so awful on the back end. Once you go through it, you would never want you or any of your clients to do that. But say that happens, we have to go get the guardianships appointed for each of the children. All those lawyers have to agree this is the right contract, the right agent, the right sales price, all of those things, because you may have a deal where you think it's your deal and the court says it's not your deal. We're going to appoint this other agent. And so we want to do everything we can to keep those relationships in place. And so if you hear those things, you want to be the first person to identify it, because as being the first agent to identify it, one, you've helped them through the process. And so by getting the ball rolling, a lot of times you will remain the agent in the transaction. That's not a guarantee, but I'm just saying from a marketing position, the more help you give someone, the more involved you are, and you're helping the attorney who's filing the probate, from the sense that you're saying, okay, we think the house is worth $775,000. You know, there's a few repairs, things like that. And so you're able to give the attorney an idea of what the net is, so that when the attorney goes to court, if they have to ask permission to sell the house, you have a really good contract to present, or you have really good you know, kind of parameters. We say we think this house is going to sell between 775 and 725. So we get a court order that says we can sell it for those amounts. And so that's where you want to be the first person to identify it. And so once again, property has been in my family for a long time. This was my mom's place. My uncle, I was always the favorite nephew. I hear that one at least a couple times a year. And I say, well, I appreciate that you were the favorite nephew, but there's nothing in the law that gives you the property, you know, and because someone just said, oh, you can always live here. This is always for you, but they never did a will. And so the state of Tennessee does not, it goes through your descendants, and it goes back up to your parents, and it goes back to their siblings, which would be your aunts and uncles, and then down to their children. It keeps going that out for 5 generations, five movements out. And so, you know, it could end up in the hands of a nephew, but a lot of times we've had cases where the most recent one that I wrapped up in February, they were trying to sell the property, but there were 38 owners. And the worst part is they have paid attorney a lot of money to tell them they were the only owner of the property, and that attorney was dead wrong. And the part that's even worse than that is that attorney is now a sitting judge. So I had to go tell a sitting judge that he committed legal malpractice, and that's a lot of fun on my part. But he agreed with it. He agreed that he had done so, and he refunded the whole legal fee. It was about $20,000 to the client, and we were able to move on. But unfortunately, this person who thought they had the property and thought they could sell the property, there were actually 38 other people involved. And so that made it a lot less fun, because a 38-way split is not as fun as a single split.
So that was a whole lot of stuff you went over just in that first 15 minutes. So so I want to kind of pause before we kind of go on maybe to another point and see what questions anyone has. There's one in the chat, and then is it Parikh? Is that how you say that?
My name's Rohan. Last name's Parikh. Yeah.
Oh, okay.
Question.
So I knew I was going to mess that up, but
it's all good.
I see you have a hand up. So
Yeah.
what question?
So my question, is more so like on a general aspect. I live in the state of Pennsylvania, and of course, it's not going to be applicable fully to the state of Tennessee. But I do want to ask, like you were mentioning the probate process with regards to wills. How long does that generally take? I'm sure it would be dependent on the assets that the individual owns and the complexity of them and all that, right?
Sure. So Rohan, I'm going to answer that from a Tennessee perspective.
Sure.
Okay. So always ask someone there in Pennsylvania, but in Tennessee, the items that are necessary to open the estate are a death certificate. And so that takes usually about 10 days, unless there's a problem. And a lot of times, even if the cause of death is at issue, we will get a provisional death certificate. Okay, so that's a necessary item, because we have to show to the court that the person is, first of all, deceased. Without proving that fact, there's nothing, you can't do a probate or an administration. And to clarify my terms, if you don't have a will, that's an intestate administration. So when I use that term, that's if you don't have a will. Probate is if you have a will. And just remember, trust is awesome, and none of this even applies. And so if you, in Tennessee, then you would then file everything. And so once you have the original will in your hands, or have determined there's not a will, you can usually file within the first 30 days. That's typical. And then we have a publication date. And that's when the death is announced and run in the newspaper. And it also depends on how busy the court is. And so we're in there in days. Oh, go ahead.
No, I was just wondering. So from the perspective of a real estate agent, should I be looking to have a licensed attorney to go through? I would imagine someone needs to have like a power of attorney, right? To be able to supply these documents.
Well, the power of attorney, and once again, I'm not correcting anything. I'm just trying to thoroughly explain. A power of attorney expires at death.
I see.
Because it can only do the actions the other person could have done. And so being deceased, they can no longer take actions. Okay, so a power of attorney doesn't help us out a whole lot in this situation. And so someone in the family either has the will, and they say, okay, here's the will, or the family, or everybody calls and says, I don't know of any will. I don't think they ever did a will. And so usually it's about 4 months. In Tennessee, it's a 4-month creditor publication. From the date of publication, there's a creditor period. So you can sell the property once you get, in Tennessee at least, once you get the will heard and probated into the court. And that's usually about day 60 because of the court's calendar and things like that. That's about the quickest you can do it, which is okay, because we're not supposed to sell property within 60 days anyway. So we're trying to meet that deadline. And then so we can sell the property then and just hold the proceeds during the creditor period. And so that allows us to relinquish the property, but have all of the proceeds there, so that we're not waiting to sell it later, because it could turn into an adverse market. There could be a downturn. It could, there could be an event that happens, something like that. And so it's kind of a bird in hand philosophy. We try to allow the agent to sell as quick. So, and our rule is once we get it open and we hit 60 days on day 61, we could sell the property. Then the state, though, the people wouldn't get their money in that case until usually about month 6 on that. That's if everything goes well. Now, if you have fighting and amongst the parties, that can stretch out. I think the longest one I've been involved with was 9 years. So,
Gosh.
Thank you very much.
and so usually day 61, they get their money about 6-month period. If everybody's fighting, they will hate themselves and spend way too much money resolving the issue. We always tell our clients, don't make a poor economic choice. And we've had people do that. They said, okay, I'm just going to include this person in the distribution because it's cheaper than fighting it for all of this time.
So we have another question, a couple of questions from Lottie. She says, how does an estate work when one partner dies and there's no will or trust?
Okay. And if I could define partner, because is partner being used as spouse, or is partner being used as a cohabitating paramour, as the law would call it?
Domestic partner, they're not married.
They're not married. In Tennessee, it depends on whether your state recognizes the common law marriage or not. Tennessee, there is no common law marriage. We hit on that last week. And so someone living with someone else has no legal rights whatsoever. They're an unrecognized party.
But what if the property is in both names and one party dies?
If it's held in Tennessee, once again, if they're not married and you have it as tenants in common with rights of survivorship, it would pass to the surviving person. Okay.
So what if it's Jane Doe and Jack Jones?
And they're not married?
They're not married, and it's not saying anything about surviving party.
Okay, then that would just be regular tenants in common, Lottie. That would be like you and me buying an investment property. You know, we just buy a house. It's no different than that, even though they have a romantic relationship. And so that part would just pass through that person's estate. Half of it, if it said Joe and Jane on title, and Joe
Right.
and Jane were not married, when one
Right.
of them pass, it does not go to the other. It just goes through if Joe dies, it goes through Joe's estate.
Okay, so if Joe does not have anything set up, that portion is going through probate? If they
It's
have
go-
children and all of that?
It's going through administration, yes. And so
Okay.
assuming, this is not always the case because I don't want to ever throw anybody in the bus, but I deal with a lot of entertainers and people in movies and stuff. And so we have known wives with known girlfriends and husbands with known boyfriends. And so we have all
Oh,
kinds
we
of,
want names.
well, I give no names.
I'm kidding.
But that's just a lifestyle we do. And as agents, that's what you deal with. We take people as they are and we resolve their whatever their choices are, we resolve that. And so in that case, that's a really bad, let's say that Joe had no children, Lottie, it would go up to his parents. And then it would go to the siblings, and then it would go to nieces and nephews, and it could end up with cousins. And so you've got somebody that now owns the house that doesn't care anything about the co-owner.
Right.
And then what happens is you would have if someone brought that to me and they said, hey, I want to sell the house, we would file a partition action. That's to sell the property, and you
Mhm.
never lose a partition action. Okay, the house, either the surviving Jane, in that case, Jane would have to buy out Joe's share at market value, or the house would be forced to be sold at sale.
Okay.
So
Yeah.
it's really terrible. It sounds like I'm being harsh. I'm just trying to explain how it happens, but that's why we're
Mhm.
trying to do this planning, because especially when we have someone that's a non-legally recognized significant other, I'll call it. The law in Tennessee doesn't allow for anything. That's very different in by state to state, though. Okay.
So is there a way to set it up if they're domestic partners and one dies, but you don't want to sell it and both partners agree? They don't want to sell the property until both dies, and then they want to sell it and split it amongst their children.
That's where they want to put it into a trust, Lottie, to govern that.
Okay.
That's
Yeah.
exactly what you're trying to do, because understand that a trust doesn't, you can set up a trust for a specific purpose or for lots of purposes. You know, and so sometimes we have that, and we had a case where we had, I'll call them good friends. I'm not for sure the exact nature of their relationship. It seems to change from time to time, but they do care about each other and they want to provide a house for each other. So that's the exact situation. They have both are not married. They have children from prior marriages, but they are cohabitating in this house and don't plan to get married, and it's very complicated. But they're going to leave that so that each of their families gets the proceeds that they put in and their percentage that they put in. So that's why it takes planning to do a little bit of that. If you just do it where you have a right of survivorship in that case, that doesn't accomplish your goal, because the
Right.
surviving person can just sell it. And if they never did anything, their estate would pull it only to their kids, cutting out the other family entirely. And that happens all the time.
See, this is why this stuff
Thank
is
you.
so important. And as realtors, we deal with people that are buying homes that aren't married, just to your example there, Lottie. And to be honest with you, I've never really had conversations with my clients about, have y'all thought about what heaven forbid something happened to one of you guys. Have y'all thought about, what you want your share of ownership, to happen to it? And I just think it's a good conversation to have with our clients and just direct them in the right place. Mark is always so good about saying we've got to be careful not to give advice, legal advice. I mean, we all know that, right? But to at least put the thoughts in people's heads that they really should plan this at the time that they're buying the house or pretty soon thereafter, so that their wishes, whatever that is carried out, again, in some horrible situation that may happen. And then Jim had a question, Mark, that said that at what point do you recommend a trust versus a normal will structure? Well, Jim, we talked a little about that last week, but I do want you to touch on it a little bit, maybe answer that just directly, Mark. And then he said, do you do anything in Ohio? Jim's up in Ohio.
I go on vacation in Ohio, Jim. That's the extent of what I do in Ohio.
I don't know if you've got anybody you could refer him to if need be, but let's just start with that question. Do you recommend, at what point do you recommend a trust versus a normal will? Or yeah.
My practice, and it's not that I'm trying to upsell someone, I see no disadvantages to a trust other than a couple hours of legal fee up front. And so I don't think there's hardly any situation where a trust doesn't survive. The only thing would be is if the only asset someone had was like a single checking account. Because there's some people that just hit the end of their life and they don't have a lot of funds left. And so if all they have left is a checking account where they're receiving a pension or Social Security or something like that, we would probably just put a payable on death and let that go that way. The issue becomes if they become disabled. So you'd want to at least have some power of attorney type language and stuff like that. But in almost every other case, I recommend a trust because of all the advantages and all the unknowns in life, because I just see it every day where there's things happen to families that they didn't plan on. We had a case recently where a son became disabled in his late 20s. And that was not something that, I don't wish that on anyone. I don't wish it on my family, and I certainly don't wish it on yours, but those things happen. And so that significantly changed their planning, because suddenly they had someone who would become dependent upon their assets for the rest of their life. And so those are the kind of things where by having some of those plans in place already, it makes that a lot easier to just make small shifts that you can do it very quickly. So when you have a change like that, they had to rebalance what they were giving each child in that case. And so I recommend a trust just universally, because the court, don't go to court for justice. You go to court to finish the process, but don't expect a court to be a good property advisor or a financial administrator. They're going to do their job and they're going to do it by the law, but they don't have expertise in either of those areas. And so anything you can do to keep it in private hands to maximize wealth is good, in my opinion.
So last week, Jim, he talked about in Tennessee, and you may want to check with your attorney up there, but he talked about, in Tennessee, everything's got to, if it's a will, it has to all go through probate. So that at the end of the day, it takes more time and money than if people would just set everything up in a trust on the front end. and then the trust just gets executed out with whatever, the plan is in the trust. And so, and for me, and I said this last week, I always thought, because I was uneducated, I always thought that to set up a trust was somebody that had a lot of wealth, that like that's who did trust, everybody else did wills. That was just my own ignorance until, I had conversations with Mark a few years ago, and he educated me a little bit more on that process. And I remember saying to him, Mark, you probably don't remember, and I'm like, why do we not learn this stuff? It's so much in my life as I get older and I learn things. I'm like, why do we not learn this stuff when we're in our 20s? So, just to be able to, like, so many stuff. But
well, the will generates a lot more income for the attorney's practice because you're going to do 2 probates later on. And so that's why typically the wills are so cheap, is just to lock in the clients, and then they're going to have two estates later. And so also I would say, Jim, if you're shopping in your area for trust work, there are people that will charge probably 5 to 7 times what we charge for the same. We just bill on an hourly rate to our clients. There are people that charge really, really huge fees for this work, and it's not warranted. And so it's not, you don't want the bottom of the barrel by any means, but you also don't want someone who always says, oh, it's a minimum of $20,000 or $10,000, because a lot of these, like in our area, my rate is $4.75 an hour. And so a lot of our family type trusts are 5.5 to 6.5 hours top to bottom. So it's money, but it's not out of place for what it's doing for the client. So that's where
well,
you
it's
just want.
money on the front end. I look at it like it's money on the front end. You take care of the estate how you want it, or it's money on the back end and your family deals with it with many more hours, as they go through probate and what have you. That's to me. So Ron asked, what are the pros and cons of corporate trust versus an individual trust?
Well, this is being taped, so I don't ever want to hurt anybody's feelings. But problem with a corporate trustee is there's probably someone at the bank or the financial advisor, and that's someone that you trust. That will not be the person that administers your trust. Okay, they will have a trust department that will do that, and that person will eventually retire and step aside. And so the problem with the corporate trust departments is that you don't have people. Oftentimes, I'm not talking about everyone, but oftentimes they don't know the individual very well. They don't know the family very well. They don't know the dynamics of the family. And so decisions are being made sometimes that are financially okay. And sometimes that's not even the case either, because I've found that a lot of trust departments tend to find the best investment to be within their own portfolio that they control, which is interesting because they get then fees for managing the money, and then they also get internal fees within the fund that they're investing in. So I'm not a big fan of the corporate trustee, but it is necessary a lot of times. And a lot of times you can have a law firm to do that. You can have an accounting firm to do that. You can have the banks do that. But it's better to pay someone just all the fees up front than to have a lot of internal costs that you don't realize you're being paid. Because there was one trust that we analyzed, and they were being charged it was right between 12 and 15%, depending on the year, management fee once you went through all the funds. That's a lot of money for a management fee. Usually it's 1 to 1.5% or something like that is more typical.
Thank you. And just a follow-up question to that. So if someone were to go the individual trust route, because corporate trusts may be questionable in terms of the personality, like the personability of that corporate trust for the individual that looks to seek it. If we're looking at an individual trust now, going on that line, at what point would it just be one person who handles that individual trust?
I recommend, now this is once again, not to do a play on words, but you have to trust your trustee. Okay, so if you don't trust your trustee, you're picking the wrong people. So this is someone that would take care of you if you were disabled, that would take care of the people that are important to you if you pass. And so I think if more than one person is in charge, no one's in charge. That's kind of the philosophy that I work under, because sometimes there's hard things that just have to be done. Like a house just has to be sold, even though it's the family home. That's the only way we can support the person in their care facility. Sometimes we just have to not give this particular child money right now because they have an addiction problem. If we give them money, we may well kill them. And so we have to be very careful that we pay their rent, we pay their groceries, we pay all their bills, we pay their education, but we don't give them cash. And so, just within the, I think it's the individual have to be someone that you trust. That's the most important quality, because understand that person can then hire financial advisors and attorneys to assist them. And so they get the professional advice, but this is the person that knows you and that you trust. And that's just my opinion. And you will talk to a lot of attorneys who will say that is the wrong opinion, and only professional trust departments should ever manage the trust. And so I just invite you to balance those two points of view and choose what's best for you. So
Interesting. I mean, so from an individual trust perspective, you find one person that you trust per se, and you have them manage all the assets, whatever they decide to do. In terms of hiring like a financial advisor or an estate advisor, whatever it may be. I'm not entirely sure what the terms and all that, brand new, but so with that being said, don't you think then it would be too much of a burden on one person, even if you do trust that individual, to like make, I guess
it happens
actions
almost
under
every day.
duress?
It depends on the extent of the estate that's being managed.
Got it.
I mean, it depends on the complexity of the assets. Like we were dealing with one, we had yesterday, I was meeting with people who have assets in London, California, and they live here in Tennessee. And so that's a more complex estate, just because we have assets that are physically located in all those areas and companies that are located in 2 of those areas. So that takes a more sophisticated choice, of people, but they had some people that they could come up with.
Got it.
But understand that you're the trustee of the trust during your lifetime, as long as you're not disabled.
Got it. That makes sense, because like one person kind of centralizes all the actions because they know exactly what needs to be done, but maybe they're not going to be the ones who actually execute the actions. Okay.
That's exactly, it's just like you would hire financial advisors, you would hire a CPA, you would hire a lawyer, you would hire a real estate agent. You're there that you would hire a real estate management company, whatever service you would hire. That trustee does not have to be the expert in that service. They just have to be wise enough to make a good choice in their choice.
That makes perfect sense. Thanks.
All right, Mark, if you had a couple other points, that you, I think that's all the questions that we had for that moment. And I'll put you on the spot as you're going through, if there's, and I know you've told a couple, but if there's a couple of stories that you could throw in, because I think that always sends the point home to, like, where you've had situations where this is what they thought was going to happen, but because of how things were set up, this is what really happened. I've been in a couple of things with you where you told some stories and I can't remember now, but it's like, wow, people think they're doing things the right way, or they don't do anything, and they thought what would happen didn't happen as the plan was.
Well, I was meeting with a client yesterday, the client's daughter, actually, who's now my client, and the husband in the situation, he is disabled and he's in a nursing home, and the wife has now passed. And the husband's concern, whether it's warranted or unwarranted, was always that his wife would remarry a gold digger and their children would lose all their assets. Okay, that was just his, I think it was a very unrealistic fear, but that was his fear, because he was blessed to have a very capable and wise wife. And so no one ever knows how he kind of got off on that. Maybe she was so wise, capable, and beautiful that he just assumed everyone would scoop her up. And so that was just maybe a compliment to her. But he was just consumed on that. And so within his plan, he had these mechanisms to protect against that. And it's been harmful to the family because it's made it very difficult to relinquish some of the assets, Kathy. And so we just had situations where we want to help do a realistic plan based on the reality of our situation, because if he did some things that are now making it very hard on his daughter, who's very capable. She's a CPA and owns a CPA firm, super capable person, but it's making it very hard for her to administer. And it also creates some conflict between her and her siblings, because they sort of blame her for the situation, and she's the fiduciary, so all she can do is what she's been instructed to do. And so we want to we want to make sure our plan reflects the reality of our situation, because he could have just put in that trust. Well, we put language in all of ours that upon a remarriage, there's an automatic prenuptial clause. You know, that's super simple. If she marries someone else, they don't get any of the assets. That takes care of his worry. But he, you know, people that know everything are difficult to help. And so that's where there's a few areas that I know things in, but I certainly don't know everything. And I hope that I'm open to always learn, because when you have a client that knows everything, that's the most dangerous client. When you have a client who knows exactly what their house is worth, for example, or exactly the best way to market their house, or all of those things, that makes typically the more difficult client. And so I have all kinds of stories. We have back to the movie. You seem to like the juicier ones, Kathy. So we had this, we have a music producer that has probably had, I don't know, over 70 number ones, you know, so pretty successful guy. And he is married, and his wife is very capable. And he lives with another woman who is his other. And they know this. This isn't a secret. They both have their thing, but their marriage stays in place. And so from an estate planning perspective, that gives us a lot of unique things, because that's a situation where he cares about someone that he's not married to. And so he had to make sure in his plan that included provisions for that person. And his wife did the same thing for her person. And so they were able to work that out. But so there's really no plan, no set of facts that we can't resolve. And this is one other thing is prior to the time where same-sex marriages were recognized, that gets into a lot of this domestic partner. And that's where a lot of the area of law and our experience had been, because prior to that time, we would have to take care of those relationships through trust, because the law did not recognize those relationships. And so that's where a lot of our planning comes from in those things. And so when we do have people that aren't marriage is not about love from a lawyer's perspective. It's just a bundle of rights. And so it's whether you want to tie yourself to someone else with this bundle of rights. And so we can plan for anything. And as your clients go through that, I would help them when they are buying a house and there's a situation where they may not have the same rights that they think they might have, to have someone set that up on the front end. So.
Good stuff. All right, do you have a point two? And so we talked about one thing that for an agent is you know, when somebody's like, you know, oh, we've had this house has been in the family for years and years. So what's another thing that agents need to kind of be aware of in educating their clients?
The most common one is my husband, my wife has just died, so the house is now mine. That could be true if the deed has that language, but oftentimes, and it depends on generationally, and it depends on, you know, what the trust level was at the time the house was purchased, but a lot of times that's not the case. And so once again, even don't assume that a spouse owns the house. Look to the deed. You can start with the tax record, but go to the deed. Number two is my spouse died, and number three would be, oh, my parents have died and I was the one who took care of them, so now I have the house. You know, that's the care of the parent is not legally significant. It's a very good thing to do. It's a very honorable thing to do, but it's not legally significant. Or we in general fraud, this is really tough, but we probably have just within our attempts 5 to 7 cases a week now of sellers who don't own the property, and they know they don't own the property. So this moves a little bit out of this, but especially if they read an obituary and someone has passed, that's an easy fraud situation. You must meet your clients. You must verify their identity. You must go through the process, no matter how irritating that is for them, because these are good, experienced agents, and these are millions of dollars in every deal. And if you facilitate a fraud, you could be complicit in a fraud, and that's a whole other issue.
A lot of that is, are you finding, so 5 to 7 a week, man, that's a lot.
5 to 7 a week. There's a group like in the Middle Tennessee area where I practice. There's just a group of about 104 attorneys, and we kind of all have this email that we kind of talk to each other on. And that's just, it comes up all the time. It's most commonly on vacant land or when LLCs are involved, or when there's an estate involved. So I touch on it. The reason I brought that wasn't just a total squirrel. We changed direction, but with an estate, that's why it's important to establish there's not a fraud, because there's somebody who says, oh yeah, I'm so-and-so's daughter, I'm so-and-so's son, they passed away. You pull the obituary and sure enough, that's what happens. And it says I left a son named Joe. Okay. It's all making sense, but we have to verify Joe's identity because they're just working hard and they're working agents, and what they tell their agents is how busy they are and they can't meet. And I apologize for doing this, and I can only talk at certain hours and all of that. And that can be very true. We have a lot of clients that is the reality of their situation, but you have to pause and you have to verify who you're dealing with. And oftentimes, most of the fake accounts are set up through Chase and Wells Fargo. And I don't want to besmirch their banks, but I'm just saying that's our experience of where the false accounts are being set up at. So if you have somebody you haven't met who wants money wired to Chase or Wells Fargo, be careful.
So if they truly are out of state, it's a state situation and there's heirs and they really aren't in town, I guess at a minimum, you want to meet them via Zoom.
Well, you can follow through and have talks with the attorney, because and you can usually fraud, the way all of our frauds so far have been resolved, by the grace of God, is that we keep chasing it down the line. And eventually they can't answer the question and they go away. So we say, okay, well, who's the attorney involved? Okay, so-and-so opened up the estate. Okay, well, we call them. And we've even called not presidents, it was the CFO of major, like a Fortune 500 company, because there was assets that they owned. And they said, yes, we get this fraud about every 2 weeks where somebody's trying to sell one of our properties. And so, I mean, I'm just saying, guys, this happens, and my world's pretty small. We're just here in the Middle Tennessee area. And so I can only imagine how big this is on a national scale.
That's what I'm saying. 5 to 7 a week just here you're hearing about. Are you seeing that mostly on lots? Like I've kind of heard that on land. Or are you seeing that in houses too?
It's mostly lands, vacant vacant lots, vacant land. We had it on the commercial building. It was pretty bold, and it's interesting because the bolder the fraud, the harder it is to figure it out.
Wow.
Because it sounds right. And so all we do is when we ask your clients, we say, hey, we have to have this. You have to do it. The reason we're asking those questions is not to irritate the client, not to do anything else, but when you have that much fraud going around right now, and you can think all of this on the electronic notary. So that's the cause of what we have.
So we need to make sure
there may have been a question.
Our client that they're legit, and we need to make sure before we're listing properties or contracting properties that we're dealing with the actual owner.
That's right.
Yeah.
I think there may have been a question, Kathy. I saw someone raising their hand. So
does anybody have a question at the moment? Elena, you're muted if you're talking.
Okay. Can you hear me now?
Yeah, but we're getting feedback.
We had this and the agent, I'm trying to see if I can turn.
Are you logged in 2 different places? Maybe that happens a lot. Okay.
This one. The agent did get, I did put it in the comment. Maybe if you look at my comment.
All right, I'll just read the comment. She put it there. She said, we had this happen to us. A fake Tennessee driver license was used as his ID. And can't read because it was a lot in MLS. Any ideas on how to protect it? So they had a fake ID. They provided a fake Tennessee driver's license as his ID. And so how do we verify true, true people, I guess, if they provide a license and the picture matches them, you kind of assume that that's the person. I mean, that that's legit.
You would, what we've started doing some is going back through the tax bill where in Tennessee, it says, please send tax bill to this person on the warranty deeds. And so you try to contact that person at that address. You try to look them up and say, you know, it's even though we have a driver's license for Joe Smith, we try to find a Joe Smith that lives at 123 Jones Street in Michigan somewhere. You know, and so we try to find that person and actually call them and say, hey, are you selling your land? And they say, well, no, I'm not selling my land. And so it takes some work. And unfortunately, on vacant land, it's just getting really, really tough, Elena. I don't have we just have to keep verifying. So that's all we can do is try to verify at every stage. But you can look at that part of the current warranty deed for ownership. So.
We've got about 10 minutes, Mark, so I want to make sure to cover anything else specifically that you were going to talk about, and then we can maybe the last couple of minutes finalize some questions.
Sure. I was just going to say one issue that we have when we have property. So let's assume we have a proper probate in place, everything's been identified, everything's working out just fine. A lot of times when we have property in a state, it might have deferred maintenance on it, because of somebody just wasn't able to do certain things. They didn't have the funds to do certain things. And so it could also be that there's just some repairs that need to be made. It could be that there's just some unpleasant things that need to be cleaned out. And so that's one where it's hard to value you have to show the value of that to the court, because they don't like to say, okay, let's sell a house for my 75, but we have to put $50,000 worth of repairs in it. So if you're doing some major repairs, you want to itemize that and have some bids for that work. Don't just have someone do it, that kind of thing, because a lot of times the court has to approve those things. It just depends on the facts, it depends on the situation. And so if you're ever trying to do that, just document well, because the court will approve anything that it has support for. If you can spend $50,000 to make $100,000, the court will approve that all day long.
And does that differ if you're dealing with somebody that just has a will and is probating, like in Tennessee, versus an estate, or is it the same for either?
Well, a trust, you don't have to do that at all, because you're not in court.
Again,
That's the whole point. But if you're doing an intestate administration where you don't have a will, or you're doing a probate where you do have a will, the court has the right to approve a contract. And so if they see a contract that comes through and has a lot of repair items, they're not opposed to that, but we want to document that we are increasing the value by more than the cost of the repairs. And so that can be a little tough when you've got maybe an odor in the carpet, or just something that's unpleasant, like if people are walking in and that's just hard to sell. So just document it and ask the court for it. And so the court does a great job. I mean, they work hard, but so I'm not against the court. I like all of our judges and I like all of our staff, but they see everything every day. And so they're not as tuned into a single transaction as we would be, because that's one of our transactions, one of your transactions. And so I would just say the repairs can oftentimes be an issue. And then also, if it's investment property, what do you do with the tenants that are in there? And so sometimes you have to file an eviction action or a termination action, or you have to give notices. So those are all things, depending on how you choose to market the property, that need to be done, because we don't want to wait until the day of closing and no one's done anything and there's somebody living there, because you can't just oust someone. Like in Tennessee, for example, it becomes a month-to-month tenancy. And to get someone out, like for example, now to get someone out by the end of July, by July 31st, you would have to file those notices in June, because you have until the end of the following month. That's Tennessee law. That's not universal. And so that's if you have a month-to-month tenancy. And a lot of times in those situations, you might not have a formal lease anymore. It could just be that someone's been there for 10 years. And so the court will say, if you've been there that long, it reverts to month-to-month. And so it's not just the probate itself, but there could be actions around that we have to deal with. We've got another estate right now where there was investment property. They have tens of millions of investment properties, and there's a lawsuit on one of the investment properties. So now we have to deal with that through the probate process. And that's a situation where they had not divvied up their assets amongst LLCs, which we recommend. And so now that's going to delay everybody getting their money and also delay our ability to sell property because we have to resolve this outstanding slip and fall case. So those are all things that can complicate our lives, but there's simple solutions. But people, I think it's, as an agent, it's as you often do, you're trying to show the client the value of doing these things. And that's just my world of it, is it makes real estate easy to move, which is what you as an agent want. You want to be able to sell real estate when you want to sell it. You want to be able to buy it when you want to buy it. Anything else, Kathy?
Anybody have any questions? Any final questions? I mean, that's, if nothing else, I hope, everybody's learned over these last couple of weeks that, I think it's important as realtors that we at least, direct our clients to make sure that they've got their assets set up, particularly their home, how they want it set up so that, just as Mark said, if something happens, it makes it easy for them, for us, for all parties to move the real estate, as their wishes would be, to whomever that it needs to go to. So, anybody have any final questions?
I have one more question regarding setting up a trust. If you have a property, going back to the domestic partners, if it's in both names, Jane Doe and Tom Jackson, but Jane Doe has a trust set up and Jane Doe passes away, but the property is still in both names. So will it refer back to Jane Doe's trust?
It depends on if Jane Doe has a pour over will in that case, Lottie, like her assets. We do a pour over will. That's when people don't put their assets into the trust. That's how we get them into a trust at death. So the better way to have it would be to have Jane and that her trust own 50% rather than her individually. That way her 50% is already, and then also protects the other partner, because in Jane's trust, we say that partner has the right to reside in that property for their whole lifetime, if that's their wish, or sometimes for 3 years, or so, sometimes there's a period on that says, because what we don't want, it's pretty traumatic emotionally for someone to lose their person they love and then also get kicked out of their house in the same couple months. That's a tough.
Right. So what if Jane has it set up, she has a trust, and we change it over to the trust on Jane's part, but I'll call him Jack. Jack didn't. So it's Jack and the trust is and Jack passes away. And
it's
Jack,
going to go through his estate, whatever that is.
whatever
his
that
part
half
of it.
is.
So his part of it, Mark, will go through the estate, right?
Yes. And I'm using that same scenario, Lottie, where it's just the two of them as tenants in common with no survivorship.
Okay.
Because most of the time they don't want the survivorship because, at least in my cases, they want someone to reside there and live there, but they want the money eventually one day to go to their family.
Right.
And so I was just qualifying that answer with that scenario. So
Okay. Thank you. Thank you very much.
oh, you're welcome.
Mark, thank you again so much for everything, for this information. And Lottie, he talked last week about a little bit more about the pour over will and, setting the estate up properly and all. So if you weren't on last week, go back and catch that. Because he kind of established, the things that you want to have in a trust if you're setting a trust up, because there's several different documents in there that he went through last week. So
where do I find that recording?
So it's on the Freedom Team in the workplace group.
Okay, thank you.
Yeah, you're welcome. Okay, well, we're going to finish a couple minutes early. Thanks again, Mark. Hopefully this was value for each of you that are here. I know it's always enlightening for me and just good information for us to have personally as well for our clients. So thank you, Mark. We appreciate your time and Appreciate you so much. And if anybody needs Mark's contact info, you know, especially if you're in Tennessee and you want to talk to him about any of this, just reach out to me and I will connect you to. All right. Y'all have a great day.
Thanks.
Thanks, Mark. Thanks, everybody.
Thank you all.
You too.
Okay.
Bye.